I'm going to teach you how to avoid your trademark being subject to the attack that Taco Bell is taking against the Taco Tuesday owners. And later on in the video, I will provide you the one free tool that you can use to monitor your trademark. In that case, that's not infringing use, that's not dilutive use, that's not generic use. Another episode of Tip Top Startups. I'm your host, David Nima. I'm one of the top trademark and technology attorneys in the country. And our goal with this channel is to help educate entrepreneurs about the legal and business affairs of innovation and help you think like a lawyer and investor. In today's episode, we're going to discuss the Taco Tuesday trademark dispute between Taco Bell and a couple of other companies that have owned the trademark Taco Tuesday. And in this video, I'm going to teach you how to avoid your trademark being subject to the attack that Taco Bell is taking against the Taco Tuesday owners. The attack is based on trademark genericness. So I'm going to teach you how to avoid your trademark from becoming generic. And later on in the video, I will provide you the one free tool that you can use to monitor your trademarks and go about your trademark enforcement strategy. So let's dive right in. Last month, Taco Bell filed 2 lawsuits against the owners of the Taco Tuesday trademark. These owners are restaurants that are obviously smaller in notoriety than Taco Bell. So Taco Bell has filed what's called a petition for cancellation in the United States Patent and Trademark Office Trademark Trial and Appeal Board. So this is kind of a mini court that operates inside the United States Patent and Trademark Office, and its sole job is to determine whether a trademark registration is valid or invalid. So in this forum, Taco Bell argue that the Taco Tuesday trademark has become generic. And if it's become generic, it has to therefore be canceled. So the question is, why does Taco Bell believe that the Taco Tuesday trademark is generic? And how can entrepreneurs prevent their trademarks from becoming generic in the marketplace? And the answer is all about trademark enforcement, okay? Trademark enforcement, or what's called the duty to police your trademark. Here's how trademark enforcement breaks down. Under the law, an owner of a trademark has a duty to do what's called monitor the trademark, the marketplace. And if the owner sees someone using their trademark in a way that could cause trademark confusion, trademark potential dilution, or in this case, trademark genericness, that trademark owner has the duty to police its trademark, to enforce its trademark. And this is usually done by way of a cease and desist letter sent to the recipient saying, hey, you're using our trademark in this fashion, and under the law, we want you to stop using it because we own the trademark, which gives us the exclusive right to this term. So if you own the trademark Pepsi, for example, and you see someone using the word Pepsi, and you think that it might be an illegal usage, such as genericness, dilution, trademark confusion, trademark infringement, anything that you see, no government entity, it's very unlikely for a government entity to go after the infringing party. And Pepsi company is going to be the party that will send a cease and desist letter and try to prevent the other party from using their Pepsi trademark. So this is kind of the protocol for trademark ownership. You have a duty to police your trademark. So in this case, Taco Bell is arguing that the owners of the Taco Tuesday trademark failed to police their trademark. They failed to monitor and enforce their trademark rights. And as a result, the term Taco Tuesday has become widespread. everyone's using it according to what Taco Bell is saying that it's basically has become such a common term that it has lost its trademark ability because the average person no longer associates the word Taco Tuesday with a particular restaurant. It's really more like a slogan for all taco restaurants to use, and that's what Taco Bell is saying. They have been using it in this fashion, and therefore it's such a prevalent term. It's so widespread use. The owners of Taco Tuesday did not police the trademark. They did not monitor and enforce the trademark, leading to the widespread use. And now the cat's out of the bag. You can't put the genie back in the bottle, and therefore the trademark is generic and should be canceled, which essentially, according to Taco Bell, liberates the term Taco Tuesday for all taco shops to use, including Taco Bell. So Taco Bell is not saying that they want the Taco Tuesday trademark. They're saying the Taco Tuesday term is not a trademark when it comes to selling tacos or restaurant services in Class 43, and therefore it is a generic trademark available for everybody. This is somewhat similar to an issue that Xerox, the trademark Xerox, faced, and also Google has faced this issue of potentially becoming what's called a generic trademark. And this happens when, for example, people say, I want to Xerox something. Instead of saying I want to photocopy something using a Xerox branded photocopy machine, which is what Xerox is or was. Xerox is a brand that's protected in connection with photocopy machines back in the 80s, and when photocopy machines were much more in widespread use. They're still in use today. And the point is that Xerox, people started saying, instead of saying I want to photocopy something, they said I want to Xerox something. And this causes potentially the term Xerox to become generic. And Xerox has taken several steps to inform the public that the term Xerox is not synonymous with photocopying. It is a brand of photocopy machines, and therefore people should not be using the term Xerox as a verb, essentially. Same thing with Google. When you say I want to Google something, what you really mean is I'm going to do what's called an internet search, right? You can certainly Google it. You can search on Bing. You can search on Yahoo. This is where trademarks fall into the potential area of genericness. So what entrepreneurs can learn from this example of the Taco Bell and the Taco Tuesday trademark issue, as well as the Google and Xerox examples that we provided in this video, is that you have a duty to police your trademark. Once the trademark is registered, as I discussed in Chapter 10 of Tip Top Trademarks, post-registration duties, once a trademark is registered, you have a duty to police, to monitor the trademark space or the marketplace. And if you detect someone using your trademark in a fashion that is creating risk to your trademark strength or trademark ownership, you have a duty to take steps and enforce your trademark against that third party, usually by way of sending a cease and desist letter. So now let's talk about the one free tool that you can install and use right now to start monitoring your trademark in the marketplace. The function of trademark monitoring is so that you can detect potential problematic use and go after it and do your enforcement sooner than later, right? I mean, you have to keep an eye on the marketplace, so to speak, right? So the way you do this, the free way of doing this is by setting up what's called a Google alert. You go to Google Alerts and you set up a couple of keywords for your brand name. Let's say your brand name is Kodak, for example. You will put the word Kodak into the search term, and you'll get notified every time the word Kodak is used and searched and scraped using the Google search engine. You'll get an email about this. And that way you will look at the email, you will click through it, you will see that maybe it was a reporter that's doing an article about the Kodak brand and history. In that case, that's not infringing use, that's not dilutive use, that's not generic use, and therefore you're not going to take any action on that. In another hand, you might see that someone else is using the Kodak term to maybe set up some kind of Amazon store or some kind of online store to sell counterfeit goods. In that case, you want to go after that person and send them a cease and desist letter. So the monitoring enables you to monitor and catch problematic use before it essentially gets out of hand or goes on for too long, so that you can go after it sooner than later. And that's what Taco Bell is arguing that the owners of the Taco Tuesday trademark did not do. They did not monitor, or if they did monitor, they certainly did not enforce, allowing this widespread use, and that's what led to genericness. I hope you've enjoyed this video. Make sure to like and subscribe and share this video with your entrepreneur friends and family members who are looking to get advice on the legal and business affairs of tech innovation. I'm your host, David Nima, and I'll see you at the next episode.